Welcome, everybody, to episode 43 of Sports Shorts, brought to you by our sponsor, the American Arbitration Association. And today's guest is Lance Tanaka, Vice President at the American Arbitration Association. Welcome, Lance.
Thanks, Bobby. Thanks for having me.
Well, as we always do with this program, the first thing we wanted to get things rolling, as it were, is to ask our guest to describe what is the job of the Vice President of the American Arbitration Association, and what's your path to getting to your current position?
Sure. Before I start off, I want to thank you, Melissa, and the SLA for having myself and the AAA participate in the program.
Well, it's our pleasure.
So my role as Vice President for the American Arbitration is to oversee the outreach and development of the AAA's ADR services. And I've got 11 states in the West that I cover. I used to be able to say everything in the West that doesn't touch water, but 2 years ago, Hawaii, which is my original home, was added to my region. So 11 states in the West is what I cover to promote the AAA's ADR services. It also includes the management of a few cases, larger complex case matters for arbitrations, and also the recruitment and training of arbitrators and mediators for the AAA's panel. So all that into the Vice President's role for my oversight. And in terms of my path, I started with the organization back in 1992 with our Hawaii office, and ran that office for a few years before getting the news of a promotion and relocation to Denver. So I've been in Denver, 24 years now. It's been a 30-year career with the AAA thus far.
And are you a lawyer?
Nope, not a lawyer. I got my training as a mediator before I ran into somebody who had worked with American Arbitration, who had identified this opportunity to work for the AAA. So I cut my teeth mediating community, landlord, parent, child disputes, small business disputes, and then eventually landed with the AAA.
And how did you find yourself in the sports world with AAA?
Good question. So in 1996, the Atlanta Games were held. AAA was called upon to provide arbitrators to be available to hear and decide sports eligibility disputes as it related to games that were ongoing. And after the Atlanta Olympics, the association tapped me to oversee the sports ADR services for AAA, which included oversight of the Olympic eligibility disputes, as well as anti-doping disputes through the United States Anti-Doping Agency's protocols.
So in that role of ADR, alternative dispute resolution models in the sports world, I think people would largely like to view that world in terms of doping cases, but I'm sure it's more expansive than just only dealing with doping cases. But obviously, that would probably be a big part of the portfolio.
Yeah, correct. And I think when you speak of the American Arbitration and its services, we've got a broad scope ranging from labor, employment disputes, construction disputes. So the whole umbrella of anything that pretty much can go to the court civilly can be arbitrated or mediated. So as a starting point, the association has a broad caseload. As it relates to sports cases, as I had mentioned, the AAA was selected to provide the arbitration services for doping and Olympic eligibility disputes. And as years passed, that had moved other organizations to look to arbitration to resolve their sports participation cases. Examples would be the PGA and the LPGA in adopting doping arbitration procedures, as well as sports integrity issues, which are subject to arbitration. So if there's a discipline or sanction that's handed out the arbitration provides that appellate right for the athlete.
Can you give us a little sense of, with the PGA and the LPGA, did you come in to help them develop the protocol for how to arbitrate disputes? Was it a discussion of a limited range of topics that would be part of this program? Or was it a broader approach to assisting them with the disputes that may exist from time to time in their organization?
Yeah, I think the broach is best described as one more of an informational and educational resource for the respective organizations. It is up to those organizations and the athletes to come to an agreement on what the arbitration process would look like. What we do is to provide information and resources for the parties, all parties, participating parties, to be able to look to an arbitration process that can provide an expeditious and fair resolution. So when there are certain procedures that seem to tilt towards one side, we're sort of there to educate the parties about the importance of maintaining balance in the process.
So I know that certainly over the past 20, 25 years, especially, the entire concept of ADR has I think come more to the fore, largely because the judicial process seems to take forever. Back when dinosaurs ruled the earth and I was a young lawyer doing litigation in California, it was like if you got to trial, it was going to be in 5 years.
Right,
it wasn't going to happen. And I think it was around that time that people started saying, well, why don't we do, they said, let's do private judges.
Mm-hmm.
And it began to grow, but you've been there, 30 years with the organization. Have you seen greater willingness for people to use your kind of services rather than the traditional judicial process?
I think we've certainly seen the growth, that business or parties that are in dispute that are looking for an alternative litigation have utilized arbitration and mediation. So there's certainly growth, and it's based on the speed of the process. Give you a good example. The average AAA case is usually resolved within 8 to 9 months from filing, vis-a-vis a court case, which could take anywhere from 2 to 3 years just to get to the trial. And if you add the appellate process to that, you're probably looking at another 2 or 3 more years. So anywhere from 4 to 6 years to be able to litigate a case with an appeal versus an arbitration which takes 8 to 9 months. Specific to sports arbitrations, I think this is where we really highlight the benefit of speed. So for example, if there were an Olympic event that is taking place tomorrow, and there's an athlete who is deemed ineligible to participate in that upcoming event, if we have a call and a request by the athlete to initiate an arbitration because it's within their due process rights under the sports bylaws, we can initiate and appoint the arbitrator today. We can convene a hearing if necessary today by conference call or video conference, and have the arbitrator issue a ruling well in advance of that game that's taking place, say at 10 o'clock tomorrow morning. Can that arbitration process be applied to any type of dispute? And the answer is yes. The requirement or prerequisite is that the parties would have to be prepared to be able to present their case. So the speed and beauty of the process is really on the efficiency that's created by it being available.
And let's say an organization has protocols for using ADR, and the AAA is a place that they're going to go to. How do you go about determining the choice of law? Is it based upon the agreement with the organization? Is it based upon where the event is happening? How does that get sorted out?
Yeah, so the arbitration process for the most part is a creature of contract or a creature of agreement. So if it's embedded in bylaws or organizational procedures that require arbitration, that is where you would see that agreement to arbitration. And typically those agreements would reference an organized and established ADR provider like the AAA. So the parties to this dispute shall arbitrate their claims in relation to any dispute that arises from this contract or agreement under the AAA's rules. The important element is having established rules to arbitrate under. Otherwise, it could get pretty cumbersome for parties if they had to create and make up the rules, procedural rules as they go along.
So for example, in a doping case, are there specific AAA rules for the resolution of doping cases versus other kinds of sports disputes?
Yes, yes. Pardon me.
Okay.
All right, back in action. So typically, sports organizations would develop their own doping arbitration procedures, and they are usually referencing the AAA's commercial rules in which the arbitration procedures would be administered in accordance with. So harmonizing with the AAA's established rules. If an organization decides to write their own arbitration procedures, it's important that they do so in a way that protects due process standards and protocols to ensure fairness for all parties. Because I think it can get in some instances very enticing to try to craft the arbitration process. But you have to be mindful that this is something that all parties who are participating are going to be viewing as fair.
So are there situations where there's a dispute, arbitrator is selected, and the organization says, oh, these are the rules that apply, and the neutral just says, okay, let me look at these rules and I'll rule based upon them?
In most cases, the arbitration agreement, which provides the set of rules, will bind and set the authority for the arbitrator. So the arbitrator is bound to whatever procedural rules the parties have agreed to adopt. If there's a conflict, between, say, supplementary doping procedures and the commercial rules, which were specified in the underlying arbitration agreement, then the arbitrator has the ability under the AAA's commercial rules to make a determination on the applicability, unless the supplemental procedures says this will control.
Now, we have a lot of students who are members of the SLA and a lot of lawyers who may never have stepped into a courtroom, purely transactional practice. Mm-hmm. So the fundamental question is, we all know that you go to court, you get a decision, you find something wrong with it, it's appealable. Arbitration?
Very good question. Arbitration is not appealable. Your sort of quasi appeal is embedded in the federal and state arbitration statutes, which allow for a party who is unhappy with the award to motion the court to vacate the arbitrator's award. And basically, you have to prove that the process or the arbitrator was somehow biased or corrupt during the proceedings, or did not entertain pertinent material evidence. So short of that, there is no appeal. However, the association and other ADR providers, I would say within the past 5 years, have moved towards the development of appellate arbitration procedures, which can be utilized in the parties' arbitration agreement. So you arbitrate under the commercial arbitration rules, your court of first instance. And if a party is unhappy with that decision, if the underlying agreement provides for the appellate arbitration procedures of AAA, they have the ability to appeal to an appellate arbitration panel to have a look at the arbitrator's decision. And that happens within a pretty finite window of usually 3 months. So assume it took let's say 8 months for the arbitration decision, and you've got 3 months for the appeal. You're looking at a process that's pretty close to a year in total for your trial and appeal.
You said that you, under the general rules, you can seek to have the arbitrator's rule voided or overruled. Does that mean that you have to go back and redo arbitration, or are you left to just go to the courts at that point?
Yeah, good follow-up question. So just to clarify, so it's not embedded in the rules, but it's embedded in the State or Federal Arbitration Act, so the arbitration law. And if for some reason a court found and ordered the vacature of an arbitrator's award, the parties would have to start again with the arbitration process with a new arbitrator. So pretty expensive and time-consuming process, which adds to the importance of making sure that it's not just trying to push the AAA, but it really is meaningful to have a neutral administrative provider administer and manage the process to ensure that there's fairness to all parties, consistent with the rules, consistent with the arbitrary code of ethics, and consistent with the established arbitration law that's out there. So sort of long-winded answer to your question. It is vitally important to ensure that the process is done fairly.
Now, you've been referencing the AAA's commercial arbitration rules, but I don't know if they necessarily apply in the sports worlds we've talked about, but there are also other AAA rules for other instances. Entertainment industry, I believe, has a special set of rules. How many of these different sets of rules, as it were, do you guys administer?
Yeah, so we've sort of grown with the legal and business climate, and the old I think preference was to have industry specific rules for all the various industries, but the common denominator was that the procedural rules really didn't change much, and what parties wanted out of those industry specific rules was the subject matter expertise of the arbitrators, of the mediators. And so we've streamlined and condensed a lot of our rules, and commercial is our base business dispute rules that parties look to. We've got labor and employment rules that are separate sets, and we've got our construction rules, which are separate sets. Industry or caseload specific type of disputes that we're seeing. If an industry wants to develop its own set of arbitration procedures, I think in most cases you'll find that it's really the arbitrator subject matter expertise that they're looking for, and that can be transported into the commercial rules.
So the key to this, in many respects, is in fact the arbitrator. So, $64 million question: how are they selected? Do they apply? Are there training programs that you rely on? Do you seek training for the arbitrators you select, and how does that process work?
Yeah, so that question is vital to the overall process. Organized providers like the AAA would have formal required training for all arbitrators and mediators. So before they can serve on a case, we put them through standardized training. And once they complete that, then their names may be submitted to parties on a list for a case. So training is required. There's a rigorous application process that panel candidates go through, and it's really based on the association's caseload need. So if your expertise or background or experience matches with an area where we have a high demand for arbitrators, there's a pretty good chance that there's a good match and need for that type of experience, then we'll continue forward to try to get that person on board. So apply based on caseload need, then we provide the training, and then you get to serve on cases. And all that happens to ensure that there's integrity in the process that can be preserved. Pardon me again. Not COVID, but it's one of those things that you just have to live with.
Yeah, everybody nowadays, you see somebody coughing and you go, oh no.
Right. But the great thing is that I can't pass it through the microphone.
So has the organization grown over the last 20 years?
Yes.
In terms of the number of arbitrators and caseload that you guys are managing?
Yep. I would say the caseload has grown and the panel has grown to mirror that caseload growth, but not enormous growth where we're adding thousands of arbitrators to the association's panel. So caseload wise, it definitely has spiked for us, and it moves with the trends of different emerging industries and where industries are facing upsides on the economy or downsides on the economy. Give you an example, not just talking sports ADR, but cannabis related disputes, cannabis industry related disputes has really spiked for us. During the pandemic, we've seen a fair number of franchise disputes arising. Pretty tough to do business in that climate, and businesses were impacted. So those are just a couple examples of where we've seen growth within at least the past 2 years.
And one of the things you talked about in your role was you said that you are involved with the management of large complex cases. And so can you sort of talk about what you're managing in a complex case and what your role is as part of the process?
Sure. So when a case is filed with the association, a case manager is assigned, and the case manager is sort of the court clerk or that buffer between the parties, their counsel, and the arbitrator, so that we can maintain the ability to oversee the overall administration of a case from start to finish. One of the biggest functions for the case manager is to help the parties during the arbitrator selection process. So we'll obtain the input of all participating parties to identify the important experience and background for potential arbitrators. And based on that information, I'll provide the parties with a list of either 10 or 15 names of potential arbitrators with their resumes. And the parties then have the opportunity to agree to their arbitrator. If they cannot reach agreement or by choice, they can independently identify their selection preferences by striking those that they prefer not to have, leaving those that they find acceptable, rank ordering them. So we'll look at the parties' list, combine it, find those that are mutually agreeable, and identify those that have the highest selection preferences. So that is what we would do to administer a case, and then we'll set the pre-hearing conference call. Parties get to establish the schedule and discovery needs with the arbitrator during that call, and establish the hearing date. In addition to that, we'll collect the arbitrator's compensation so that the arbitrator is left out of that discussion, uncomfortable discussion with the parties about here's how much I need and here's what, where's my money? I haven't seen the deposit. So we take care of that to maintain and preserve the arbitrator's neutrality.
So generally, when somebody wants, let's talk about the basics. So I have a dispute. We have a contractual provision that says we'll submit it to the AAA. Is it generally one party, or one party can start the process? Do both have to start the process? How does that work?
Yep.
What are the mechanics?
So as long as there's an embedded arbitration agreement in the underlying contract, either party may commence the process. And in some instances where there is no underlying agreement to arbitrate, parties have agreed post-dispute to submit to arbitration. So that's the instance where we would have all parties mutually agree, sign a piece of paper that basically validates their agreement to arbitrate. Otherwise, in a arbitration agreement that's embedded in the contract, either party may file a case.
And then once the case is filed, is it like a more traditional, as it were, judicial process? Somebody files a complaint and an answer is due, or what are sort of the steps once that first step action is taken?
Sure, I'll try to walk you through it real quickly. So a demand for arbitration is filed. We'll confirm receipt of that demand, and we'll set 14 days for an answer to be submitted. If the responding party decides that they do not want to submit an answer, then it's treated as a general denial to the claim. We will then commence the process for initiating on larger dollar cases, what we call an administrative conference call, where I'm going to reach out to you and get your input, reach out to the other side at the same time to get their input on the experience and background. With that information, then I'll formulate a list and we'll start the arbitrator selection process. You have 2 weeks to identify your selection preferences. We get that back. We'll reach out to the mutually agreed upon arbitrator and invite them to serve. They have to then provide any disclosures that they may have with counsel or the parties, or any possible witnesses, because we usually have a list that's provided by the parties. They'll make that disclosure. We'll afford either any party the opportunity to comment or object to the arbitrator service based on that disclosure. We'll make an administrative determination as to whether or not the arbitrator continues. Let's just say we confirm the arbitrator's appointment despite a disclosure that we felt would not create any potential bias for the parties or for the arbitrator. Then we'll set a pre-hearing conference call, and then that pre-hearing conference call then sets the schedule for the arbitration, and that's pretty much it. Once that schedule is established, it's up to the parties to engage in whatever discovery needs they need to undertake. If there's a need for depositions or interrogatories, arbitrators entertain those and make decisions as to whether or not those are appropriate for the case. You have your hearing date, opening statements, exhibits, witnesses, cross-examination, direct examination, closing arguments. The arbitrator then closes the hearings, and the arbitrator then has 30 days to issue their final decision. And that 30-day time window is one that the association really makes sure is held to, because that goes to the beauty of the process in terms of the expeditious resolution.
So the process is really determined on a case-by-case basis, whether or not they're even going to allow depositions that might be allowed under state law, and whether how parties are subpoenaed and what sorts of other discovery may be had. So it generally is built to expedite the process so that you can get things done within 8 or 9 months from start to finish.
Yes, yes. And the commercial rules for the AAA were developed and established, a wide range of latitude for arbitrators to decide discovery needs and issues. But it's premised upon the ability to have an expeditious resolution. So being able to articulate and convince the arbitrator that certain types of discovery is necessary and relevant is going to be of utmost importance to counsel to make that argument.
Well, Lance, this has really been great. Not only do we appreciate AAA's sponsorship of this show, but the longtime sponsorship of our organization, which is very much appreciated. And it was really great to hear about how it really works. I think many of us, don't really understand the nuance of it, other than it's a faster way to get a resolution. But I think you've shed a lot of really important light on how it works and how the AAA operates across a variety of industries. So I can't thank you enough for taking out the time and talking with us a little bit about it, and look forward to many more years of the Sports Lawyers Association working together with AAA.
Well, thank you, Bobby, and thank you, Melissa, and thank you, SLA, for having us. We appreciate the opportunity and look forward to our continued work together.
For those of you that want more of the SLA, please go to our website, sportslaw.org, and become a member of the Sports Lawyers Association and get invited to all kinds of interesting events. We have some events that are only open to members, and take advantage of it and pay close attention, because this November we're doing a sports media symposium in early November. Stay on alert for that. Should be very interesting programming. And of course, next May we'll be in Los Angeles, my hometown, for our next Sports Lawyers Association annual conference. So until then, Lance, thank you. Thanks AAA, and we'll see you all in a couple weeks.